explanation why an innocent person would be looking for an alibi before he's accused of the crime?
Your Honor, you touch on the corroboration issue. No, and our point is there was no looking for the alibi. I proposed it, I guess, in my rebuttal time, but the corroboration evidence, you have to look at the record as a whole. You have to read the testimony of Ms. Nimmons and Ms. Murphy. And what you have there, first, the key point on that.
The document the school produced didn't match the document that your witness produced.
The sign-out sheet.
The sheet was different dates on the sheet.
Yes, go ahead. And I'll still allow you your rebuttal time. Answer this question.
Absolutely.
We want
the
to hear from Mr.
corroboration
Hines.
issue rests on one point. That one point is they say, why would someone have gone to get the June 2nd sign-out sheet on June 3rd when they weren't arrested for the crime until June 22nd? The key issue there first is remember that sign-in sheet, and they were both originals kept under lock and key. Our client never got any originals. That sign-out sheet exonerates our client. It says that at 3 o'clock, he was in a place that was more than 20 minutes away from where this robbery took place.
Indeed, both versions exonerated the client.
Exactly.
But how can two versions possibly? You've got two versions that exonerate you. Doesn't that scream faked alibi?
Your Honor, no. One of them was mistaken, obviously, but our clients didn't make the
No. Wait a minute. One was mistaken.
One was wrong. One had the wrong date on it.
Wait. They shouldn't be. How come two exist? I don't care about mistaken.
I agree.
So one of them is a fake. Who faked it?
Your Honor, our client never had possession of the original documents. The testimony is clear.
I understand that I'm impugning the integrity of the school official who prepared the sheet. But what other inference does the evidence leave open?
The only inference, to my mind, because there's no one suggesting that this school was faking an alibi. The only inference.
I'm suggesting it. Not the school as an institution, but the teacher.
All right. Why don't we just leave this and continue this on rebuttal? Okay. I want to hear from Mr. Hines. Patrick Hines. Good afternoon.
Good afternoon, Your Honors. First, to clear up the question about the pinkish lips, I believe counsel is right that the officer who testified at the suppression hearing did not mention the pinkish lips. However, he's also correct that the pinkish lips are documented in the police reports. And when the victim testified at trial and was able to testify about what description did you give the police, she did mention the pinkish lips.
The puppy dog eyes were new at trial.
The puppy dog eyes were new at trial. That came out on further examination, trying to get the witness to elaborate more about what she meant by recognizing his face.
While the witness was sitting in front of her.
While the defendant was sitting in front of her. But the pinkish lips came out when he was not. I have the trial exhibit with me. It's reproduced in the supplemental appendix at page 2, and I think it's pretty clear that the pinkish lips are the defendant's most distinctive facial feature. You might even be able to see it from there.
That's not an unusual feature, is it?
No, it's not
a
unique feature like the like the combination.
My question to you,
it's not
among
unique.
African Americans, that is not an unusual feature.
No, I understand that, but it is.
It's not unique like a scar or some other facial disfigurement.
But it is much more unique than 6-foot black man in his 30s.
Well, let me ask you about LeGrand. If we disagree with you and we feel that this is one of those cases that falls within the ambit of LeGrand, what would you suggest that we order? Do we order a Fry hearing on all these factors? Are there just certain factors?
Well, it's difficult to see.
If we were to decide we want to do a remittal.
It's difficult to see how you could order a Fry hearing on these papers, even as those papers were supplemented by the oral reproffer. Part of the problem in this case, and I suggest it's a problem that the defense created for itself, is that they had 15 different subjects that they were trying to proffer.
Or they waived 5.
No, they ultimately waived 5, but I'm talking about their initial papers. They had 15 topics.
You didn't object.
And pardon me?
You didn't object to the motion.
No.
So all 15 were perfectly fine with you. So how can you now argue, well, gee, they had so many in there? I would have thought if the people had a problem, they almost done, they would have argued, Judge, this is overbroad. How are we ever going to address this? We can't do all of these. In fact, the only ones that make any sense in this case is the weapon, the stress, et cetera.
Well, as a matter of fact, that's exactly what the court did. So all of this is preserved because it's preserved by the court, even though the people didn't take any position. But my point is not about overbread. My point is that in order to get a Frye hearing, I think that the proponent of the testimony should be under some obligation to make a showing, as required by Legrand, of relevance. The principles are generally accepted by the
Why should he move for a Frye hearing? He just wants the witness to testify. You got a problem, you should ask for the Frye hearing, shouldn't you?
No, he wants the witness to testify,
And you've got no objection. So,
but if there's going to be a Frye hearing, I mean, the ordinary way that a hearing is led up to is that the proponent of the evidence makes a proffer, the opponent either disputes or doesn't dispute elements of the proffer, and then you have a hearing to resolve the dispute.
well, if that's unique to criminal law, it didn't happen on my watch, and my understanding is when you say I've got a witness that's going to come in, that's going to testify that this person suffered a serious facial scar or something let's say on a difference between a second and a third, you don't need a Frye hearing. You just put the witness on, unless somebody wants to say, wait a minute, this is outside the normal science or whatever. But nobody objected to this. And the only thing the judge said was, you got too many issues. And so then they cut it down. So it seems to me the person comes in, this is exactly what you do. And the only reason you need a Frye hearing is if you want to say the science is screwy. And no one's saying that.
Well, we may have a difference about the scope of the Frye hearing. I mean, I'm inclined to agree with you that Frye hearings are about the science. The defendant has argued and has cited some case law for the proposition that Frye hearings are actually bigger than that, and Frye hearings are where you also decide issues like whether things are beyond the ken of the jury.
I guess the question is, did the people preserve the position that they're entitled to a Frye hearing, or did they preserve anything they're now arguing? I'm confused about the sequence. He said, I want to call an expert. The people said, fine. The judge said no?
The people didn't even
speak said
on the record. The people said nothing.
So before the
judge said it's premature, it's overbroad. Certain of these factors don't appear to apply here. Other factors, even though they may apply, and I'm speaking particularly about witness confidence here, even though witness confidence applies,
he said for whatever reason, and maybe because we're assuming for the moment we're going to find that he was wrong. Assume that he erroneously says no. Do you have any problem with having preserved the point that you're entitled to a Frye hearing or whatever else you're preserving?
Well, I certainly think there has to be a hearing before there can be a
No. The question is whether you've preserved it.
Oh, I'm sorry.
Have you preserved the argument?
The people did not file papers or make an argument that says that
you're saying you were never called upon to respond, so you can't have a preservation problem. The judge ruled in your favor before you could open your mouth.
Exactly.
All right.
But he didn't rule on Frye. He just said you got too broad a scope.
No, he didn't rule on Frye, but he denied the motion without a Frye hearing.
Right.
So we're not going to pop up and say, hey, let's have a Frye hearing.
But the whole argument of Frye is irrelevant. I mean, it's not an issue here. Right?
Well, it's an issue as to whether the showing that was made by the defendant was sufficient to get the expert granted without a Frye hearing.
No, there's no objection to the expert. The only objection is to, as I understand it, is to what he can testify to. Can he testify to the knife, to the this and to the that? Right?
Well, I mean, as I said, the people said nothing at all. Whatever is preserved here is preserved by the court.
And the only issue, as I understand it, and I could be wrong, was if the judge seemed to think there was sufficient corroboration of the idea that the expert was irrelevant, not that he was unqualified.
No, that was the appellate division.
Or that the issues were not of equality.
No,
the judge just flat out denied the appearance of the witness, right? He just said you can't testify.
Right, denied the appearance of the witness on...
Didn't say whether it was relevancy grounds or whatever.
No, he did say that it was because the issues as proposed by the defendant on this one page of paper were not beyond the ken of the jury.
That's what he said, okay.
Yes, that was the ruling, except with respect to witness confidence, which the defense spent a lot of time talking about.
So
witness confidence, the judge said, we can take care of that with a charge because I will charge the jury with exactly what you want your expert to establish. I will direct them
But he did not have the benefit of a grant.
So an expanded ID charge. He would give an expanded ID charge.
He would not only give an expanded ID charge, but he would tell the jury that a witness's confidence is not a reliable indicator of accuracy.
Is that what he did?
Yes, he did. I have the charge in front of me, and it was not, the defendant tries to claim that this is a perfunctory charge.
Is that exactly what he said, or did he say it doesn't equate to accuracy?
He said, well, I've got it right here. He said, certainty and accuracy are different concepts.
Yeah, I know. Put that down for your COE.
Those are self-evident truths, aren't
Sure.
they? And
Thus-
that's really something different from what an expert would say.
Okay, well, let me continue. Thus, even if the witness appears to be completely certain that she has the correct identification, you may not rely on that confidence alone. You must instead make your own determination as to her credibility and the accuracy of the
Still
identification.
sounds pretty self-evident to me. I mean,
Yeah, and
it's
how
not
did
the
they make-
same as-
I'm sorry, Judge.
Go ahead.
Well,
And how do they make that? You know, it would be nice, I mean, you have to concede that an expert would have said more than what the judge just said.
An expert could have testified for an hour, certainly.
Yes, and he would have said why that's true. And he would have said, you know, these are the factors that make this certainty not so certain. And then they could weigh that.
And then the judge would have told them, you don't have to follow what this expert says. You can reject that if you want to. It's up to you.
Right.
That charge would have been much less favorable than this charge.
So you're helping the defendant out here.
I think that a judge directing a jury that they must determine for themselves that issue is better for the defense than a judge telling the jury that you heard this expert, you can either follow or not.
Can you imagine anyone arguing that the charge you've just read was incorrect? You said, no, the jury shouldn't determine for themselves, they should take they should take the witness's word for it?
No, but the point is not that the charge isn't obvious. The point is that the charge tracks what the defendant said on this piece of paper he wanted his expert to establish before the jury. An eyewitness's confidence level is not a good predictor of identification accuracy. That's all the defendant said he wanted his expert to establish. If he wanted
even not a good predictor is a little more than the judge said. But let me go to something else. Assume you've got a point here that this is that there's nothing much that the expert could say in this case that would be all that devastating. What harm is done? I mean, it doesn't. I mean, if you have a witness who can't really say anything that is going to impair the jury's faith in this in this witness, what's so terrible?
What's so terrible about having experts testifying?
That's good for you. Your case
endlessly?
is strengthened. They call an expert and you take him apart on cross-examination.
It's entirely possible to do. I mean,
obviously had no
there's a lot of wasted time. There's a danger. There's always a danger with experts that the jury's
to refine my question, isn't what Legrand might be read as really saying is when you have a typical one-witness ID case, and maybe we can call this a typical. I mean, I said it was strong. He said it was weak. It's your ordinary one-witness ID case. When you have that, I don't know whether the expert might help, he might not, but let the jury decide. Let the jury hear the expert and figure it out. Is that a fair interpretation of Legrand?
I don't think it's a fair interpretation of Legrand because Legrand says, Legrand talks about whether there's corroboration, and Legrand talks about the 4 factors that have to be established.
Well, you don't have any corroboration except the after-the-fact corroboration, correct?
Well, the after-the-fact corroboration is nothing to sneeze at, in our opinion.
Oh, no, I understand.
For exactly the reasons you stated.
Don't we have to, I mean, if we were being asked to reverse the judge, you'd say it was outrageous to reverse him on the grounds of something that came up into the trial after he made his ruling. Can we affirm him on the basis of something he didn't know about?
Well, we can affirm him on the basis that his ruling was ultimately shown to be the right ruling. He didn't have the information in front of him, but that was because we didn't have the alibi notice to conduct the investigation that would have led us to that information.
Isn't the test of whether there was error the record that the judge had in front of him when he decided? I grant you it could become harmless in light of later events, but whether it was error depends on what he knew then.
Well, Your Honor, I mean, in my brief, I've analogized this to the admissibility of co-conspirator statements, where it seems pretty clear that if a co-conspirator statement is received in evidence, what the appellate court does to determine whether that was a correct ruling is look at the entire record to see whether there's a prima facie case of conspiracy established on the record.
Take the corroboration out of the case, just hypothetically. At that point, you've got a Legrand violation. Even the appellate division seemed to think you had a Legrand violation. Suppose his alibi witnesses had helped him instead of hurt him.
Well, I don't think we have a Legrand violation because I think that Judge Wetzel's ruling was correct insofar as what the defendant proffered he wanted his expert to establish, that these things, with the exception perhaps of witness confidence, are all within the ken of the ordinary juror, and that with respect to witness confidence, the charge instructed the jury in mandatory fashion to follow